I need to explain some things first, because the ending only lands if you understand how deliberately, patiently, this whole mess was built before it ever became my problem to fix. My daughter Ren is 26 years old. She was in a car accident 8 years ago that left her with a spinal cord injury and permanent paralysis below the waist. She's independent in almost every way that matters. She works remotely as a graphic designer. She lives 2 doors down from my husband Thomas and me in a townhouse she bought herself, in a community called Fallowfield Ridge outside Columbus, Ohio, specifically because it advertised accessible unit modifications and had, on paper, an accommodating HOA. Her van is a modified Dodge Grand Caravan with a side entry ramp, and it requires a specific amount of clearance on the passenger side to lower and extend safely, which is exactly why, before she even closed on her unit, she requested and received a designated accessible parking space directly outside her front door, wide enough for the ramp, with the correct signage and blue-striped access aisle painted by the association's own contractor. That was 2 years ago. It worked fine for 2 years. Then, last spring, Brenda Suchak joined the HOA board as Parking and Compliance Coordinator, and within about 6 weeks of taking that position, she decided Ren's space was a problem. I want to be precise about what actually happened, because Brenda was clever enough to never frame this as being about Ren's disability directly. She framed it, from the very first conversation, as being about paperwork. She sent Ren a letter in April stating that her accessible parking designation could not be located in current board records and that she would need to resubmit documentation to maintain the space, or it would be reassigned as general visitor parking. This was already strange because the space had existed, properly marked and recorded, for 2 years through 2 previous board compositions without a single issue. But Ren, being reasonable and not wanting a fight, gathered what she'd been asked for her state disability placard renewal, the original HOA accommodation approval letter from 2 years earlier, and a note from her physician confirming the medical necessity of a wide accessible space for a ramp-equipped vehicle, and mailed it to the management company as instructed. 3 weeks later, Brenda sent a second letter claiming the documentation was incomplete because it didn't include a copy of Ren's vehicle registration cross-referenced with the placard number. This is not a standard requirement under Ohio's disability parking statutes, which recognize a valid state-issued placard as sufficient documentation on its own, displayed in the vehicle full stop, no registration cross-reference required by law. But again, Ren, not wanting to escalate anything, went and got the registration copy and sent it in. By this point, I was hearing about all of this secondhand, mostly through Ren mentioning it in passing during dinner, the way you'd mention an annoying customer service call, not something that felt like an emerging crisis. I didn't get directly involved yet, partly because I trusted Ren to handle her own affairs, and partly, honestly, because I had just been through the confirmation and swearing-in process for my new judicial position and had very little bandwidth left over for anything outside the courthouse. That changed on a Tuesday morning in early June. I was getting ready for work when Thomas came into the kitchen holding his phone, his face doing something I don't see often, somewhere between disbelief and fury. "Ren's van is being towed," he said. "Right now she's still in it." I want to walk through exactly what had happened, because every detail of it matters for what came later. Ren had pulled into her assigned accessible space to head to a doctor's appointment. She'd extended the ramp, was in the process of transferring herself and her wheelchair down onto the pavement, a process that takes several minutes and requires the vehicle to remain stationary with the ramp deployed, when a flatbed tow truck pulled up directly behind her van. The driver, a contractor working under a towing authorization from the HOA, told her the vehicle needed to be removed because it lacked a current authorized parking permit for that space. Ren told him from her chair, mid-transfer, ramp still extended, that she had a state disability placard displayed on the dash and had submitted every document the HOA had requested over the past 2 months. The driver told her he'd been given direct authorization by a board member, Brenda Suchak, by name, and that he was required to proceed unless she could produce a current HOA-issued parking sticker, which the community had apparently just implemented as a new requirement that week, one nobody had informed residents about yet. He hooked the van up while my daughter sat on the pavement, in her wheelchair, ramp still extended from a vehicle now being lifted onto a flatbed, and called me because she genuinely did not know what else to do. I left work immediately and drove to Fallowfield Ridge, arriving as the tow truck was pulling out of the community with my daughter's only accessible vehicle chained to the back of it, while Ren sat in the parking space in her wheelchair, understandably shaken, having just watched her mobility and independence get physically hauled away over what amounted to a paperwork technicality that hadn't even been properly communicated to her. I am not generally a person who loses her composure in public. 19 years of courtrooms will train that out of almost anyone. But I will admit that standing in that parking lot, watching my daughter's van disappear down the street while she sat on the asphalt in a wheelchair, because a woman named Brenda Suchak had decided her documentation still wasn't good enough after 2 rounds of exactly that documentation, something in me went very cold, very quiet, and very focused. I did not scream at anyone in that parking lot. I did something I'd trained myself to do for nearly 2 decades instead. I started building the record. The first thing I did was call the towing company directly, get the name and license number of the driver, the authorization reference number he'd been given, and the exact time of the tow, all before the flatbed was even out of sight. The second thing I did was photograph the empty parking space, the accessible signage still clearly mounted on the post beside it, and the blue-striped access aisle painted on the pavement, all still fully intact and unchanged from when the space was originally approved 2 years earlier. The third thing I did was sit with Ren on a bench near the clubhouse and have her walk me through, in careful detail, every letter Brenda had sent, every document she'd submitted in response, dated, in order. What became immediately clear, once I had the full sequence laid out, was that Brenda hadn't lost paperwork or found a genuine compliance gap. She had manufactured a moving target. First, the space wasn't in records. Then the documentation was incomplete. Then, apparently, an entirely new sticker requirement had been implemented that same week, with no advance notice to residents, timed in a way that conveniently gave the tow truck driver something new to point to the moment Ren produced everything previously requested of her. I've spent 19 years reading exactly this kind of pattern in discovery documents during disability access litigation. It has a shape to it, and once you've seen that shape enough times, it's impossible not to recognize it immediately. This wasn't a paperwork problem. This was someone deciding, for reasons I didn't yet understand, that my daughter's accessible space was a problem she wanted gone, and using an escalating series of manufactured technicalities to make it disappear without ever having to say the real reason out loud. I retrieved Ren's van from the impound lot myself that afternoon, paid the release fee under protest with a written notation that I intended to dispute the charge, and drove Ren home. Then I went back to my own townhouse, sat down at my kitchen table with a legal pad, the way I have for nearly 2 decades before every serious case I've ever built, and started writing down every fact, every date, every document, every name. I hadn't yet told Brenda Suchak who I was. As far as she knew, she had just towed the van of an ordinary homeowner named Ren Marsh over a stack of manufactured paperwork issues, and that would be the end of it, the way it probably had been the end of it for whoever came before Ren in whatever pattern Brenda had apparently been running. She had no idea that the woman writing that legal pad full of dated, documented facts at her kitchen table that night had been sworn in as a Superior Court judge 11 days earlier, had spent 19 years litigating exactly this category of case professionally, and was about to make absolutely certain that Fallowfield Ridge's HOA understood, in precise legal terms, exactly what it had just done to a disabled resident, and why it could not simply be allowed to happen again. I didn't call Brenda Suchak that night, and I didn't call her the next morning either. 19 years of practicing law taught me that the person who reacts first, out of anger, in the moment, usually gives away more leverage than they gain. What I did instead was spend 3 days building a record so complete that by the time I finally sat across from anyone at Fallowfield Ridge, there would be nothing left for them to dispute, deflect, or explain away. I requested, in writing, a full copy of the HOA's parking policy as it existed on file with the state, along with any amendments filed in the past 12 months. I requested copies of every letter sent to Wren, officially, through the management company, to compare against the copies she'd kept herself. I requested the specific board resolution, if one existed, authorizing a new parking sticker requirement, along with proof of the date it was communicated to residents. And I requested written confirmation of exactly who had authorized the tow truck company to remove a vehicle displaying a valid disability placard from a marked accessible space. The management company, to its credit, responded quickly and nervously, which told me they already sensed something had gone badly wrong. What came back confirmed everything I suspected. There was no board resolution authorizing a new sticker requirement. Nothing had been filed, voted on, or communicated to any resident before the day Wren's van was towed. The new requirement, Brenda cited to the tow truck driver, had been invented, verbally, by Brenda alone, sometime in the days immediately before the tow, apparently as a final justification, once Wren's actual documentation ran out of technicalities to exploit. I also learned something else, something that finally explained the entire pattern. I asked a neighbor who'd lived at Fallowfield Ridge for over a decade, casually, whether she knew anything about Brenda's history with the community, and she told me something I hadn't expected. Brenda had, 2 years earlier, personally requested that exact parking space for a family member's temporary medical accommodation before Wren ever moved in, and had been denied by the previous board because the space had already been permanently designated accessible under state accommodation requirements and couldn't be reassigned on request. Brenda had wanted that space for years. She simply hadn't had the position or the opportunity to take it until she got herself onto the board as parking and compliance coordinator, and Wren's arrival with a paperwork gap she could manufacture had finally given her one. I want to be careful here, because I never found a smoking gun document where Brenda wrote down, "I want this space for myself." What I had was a documented pattern of manufactured technicalities, an unauthorized policy invented on the spot, an illegal tow of a vehicle displaying a valid placard during an active accessible transfer, and a personal history connecting Brenda directly to that specific space. In a courtroom, that's more than enough to build a compelling case. Outside a courtroom, at a board meeting, it was more than enough to end her. I requested a formal meeting with the full HOA board, not just Brenda, citing Ohio's planned Community Act provisions around resident access to association records and grievance procedures. Harold Denning, the board president, agreed to convene it within the required window, and I made sure through the management company that Brenda Suchak would be present, since the meeting concerned decisions she had personally authorized. I brought Wren with me, though I told her beforehand she didn't have to say a word unless she wanted to. This wasn't going to depend on either of us raising our voices. I brought my legal pad, now transformed into a clean, organized packet, dated letters, the confirmation that no sticker policy had ever been adopted, the towing company's own written confirmation of who authorized the removal, and photographs of the intact accessible signage that had never once been the actual problem it was framed as. I also, for the first time in this entire process, identified myself formally and on the record not as an intimidation tactic, but because it was directly relevant to what I was about to explain. I told the board that I had been sworn in as a Superior Court judge several weeks earlier, and that prior to that, I had spent 19 years as a civil litigation attorney, a significant portion of that career focused specifically on disability access and accommodation law. I watched Brenda's posture change the moment I said it. The way people's posture changes when a threat that felt abstract suddenly becomes specific and detailed. I laid out, calmly and without theatrics, exactly what I laid out earlier in this account: the pattern of manufactured documentation requests, the invented sticker policy with no board authorization, and the fact that towing a vehicle displaying a valid, visible disability placard from a designated accessible space, particularly during an active accessible transfer, isn't simply a rude inconvenience. It intersects directly with protections under both Ohio disability parking statutes, and depending on how the HOA's overall policies are structured and funded, potentially broader fair housing accommodation obligations as well. I explained plainly that an HOA authorizing that kind of tow without a validly adopted policy behind it exposes the association and potentially the individual board member who personally authorized it to real legal and financial liability, not hypothetical liability, the kind I had spent 19 years litigating on behalf of clients exactly like my own daughter. I didn't threaten to sue. I didn't need to say the words out loud. I simply laid out factually what the law says, what had actually happened, and what the potential consequences were if it continued. Judges, even off the bench, tend to have a particular way of stating facts that makes threats unnecessary. Brenda tried, initially, to argue that she'd been acting in good faith, that the documentation genuinely appeared incomplete to her, that she hadn't known the sticker requirement wasn't formally adopted yet. But every attempt she made ran directly into a dated document I had already placed in front of the board contradicting it. When Harold Denning asked her, directly in front of the full board, whether she had personally called the towing company and authorized the removal of a vehicle with a visible disability placard, without any board vote behind her, she didn't have an answer that survived contact with the paper trail sitting on the table. The board voted that same night to formally remove Brenda Suchak from her position as parking and compliance coordinator, citing unauthorized enforcement action and failure to follow adopted board procedure. She resigned from the board entirely within the week, before the association's own bylaws process could formally proceed against her, which most residents who later heard the full story understood, correctly, as an attempt to leave quietly rather than have the details spelled out in official minutes. I also, separately from the HOA matter, filed a formal complaint with the state agency that licenses towing companies in Ohio, specifically regarding the removal of a vehicle displaying a valid disability placard during an active accessible transfer, a detail I made sure was documented clearly and specifically in the complaint. The towing company responded within 2 weeks with a formal apology, a full refund of the impound fee Thomas and I had paid under protest, and confirmation that they had reviewed their intake procedures with drivers regarding accessible vehicles and active transfers going forward. The HOA, under Harold's direction, and with actual legal review this time, rather than one board member's personal initiative, rewrote its entire parking enforcement and accessible parking policy from the ground up, with a mandatory legal compliance review built into any future changes to accessible designations. Wren's space was formally reaffirmed permanently in writing, with a citation to the original approval and the applicable state statute attached directly to the file, so that no future board member could ever again claim it couldn't be located in current records. Wren still lives 2 doors down from us. Her van sits in that same space most days, ramp folding out onto the same stretch of pavement where she once sat in her wheelchair, watching it get hauled away over paperwork that was never actually incomplete at all. She doesn't talk about that day much, and I don't push her to. What she has said more than once is that she's grateful I was there, not because a judge fixed it, but because someone finally took the time to write everything down, date by date, document by document, and refused to let a manufactured excuse survive contact with an actual record. I think about that distinction often, now that I sit on the bench myself. Most people who abuse a small amount of power in a homeowners association aren't counting on being caught by someone with 19 years of relevant legal experience and a freshly sworn judicial title. They're counting on exhaustion. They're counting on people giving up after the second letter, the third technicality, the fourth requirement invented after the last one was met. Wren didn't have the tools to fight that exhaustion alone that day in the parking lot, and she shouldn't have had to. But she had a mother who did, and in the end, that turned out to be exactly enough.